Updates. Today, me and my business partner Emily are going to discuss about update on the interfilings. That means that especially for the 485 cases where we're transferring from EB-3 to EB-2, what's going on, when the receipt notices are coming up, when the approvals are coming out. We're going to give an update to that. We're going to also discuss about if we have a problem with USCIS, for example, delay, unnecessary delays, denials, wrongful denials, completely wrongful denials. What do we do at that point of time? Do we contact the Ombudsman's office? Do we contact the Congressman's office? What are the steps that we should be taking if we have a problem with the USCIS? And also, we're going to discuss about studying an H4s, the pros and cons. A lot of people ask the question, should I move to F1 visa? Would I be able to get in the master's quota? If I'm in the H4, we are going to address those issues. We're going to also address some of the issues with regard to the H4 EAD approvals that we are receiving it. But the H4s are not getting approval. This is becoming a little bit common. We're going to discuss about that. Emily, what's going on the interfiling? Interfiling has been there, transferring from EB-3 to EB-2, and sometimes from EB-2 to EB-3 we have done it. It's been historically there, but we didn't used to do with the 485J supplement. Now they started the new thing called 485J supplement starting in January of 2022. What's going on that, Emily?
Yeah, we're definitely seeing some improvement in terms of how fast we're getting receipt notices for 485J submissions for interfiling to transfer the basis from the EB-3 to the EB-2. We did get confirmation from USCIS that their process with that, once they receive the package, is to scan it, upload it into their system, and then electronically notify the officer that it's there so that the officer can actually view it without having to get the physical file. So everything's going to California, but it's all available electronically for the officer. And USCIS has been picking up the pace in terms of getting those uploaded and getting them to the officer. We are starting to see more and more interfile cases getting approved just in May, I would say. So that's a good sign there. It has created some additional issues in situations where the person's no longer with the company, and can you interfile in that situation? How do you get back into EB-2? But it seems to be heading in the right direction.
Yeah, at least I'm pretty positive that the USCIS is heading in the right direction. I may not like the pace at which they're heading it, but at least they're heading in the right directions. I mean, what do you think so? They're going to use up all the 290,000 green cards? You had a session on the TV Asia Sunday on the discussion.
Yeah, I don't know if they're going to quite use them all up. They had some issues at the beginning of the year related to EB-5 where they didn't know if they would, what the numbers were, so they were kind of going at a slow pace. They have picked up the pace earlier compared to what they did last year, so I think they're going to do better than they did last year. Are they going to waste 0 green cards? I don't know. I don't know if they can get to 290. But they did suggest previously, they had told us that if you filed in April 2022, under the April visa bulletin, you should be able to receive your green card by September 30th, the end of the fiscal year. And then they even updated AILA a week later saying if you filed in the first week of June 2022, they had every intention of approving those.
That is this week.
Yeah. Mm-hmm. So I don't know if I'm going to hold my breath given their history, but
I still recommend all the people to keep writing letter to the Congressman. We have given the details of the letters, what kind of letters that you need to write. I mean, you can use those things or write your own letters, write your stories, why these delays are going to cause problems for you. Please keep writing letters. That keeps a pressure on the USCIS. Look, they're not telling the same thing with the family-based immigration, that they're going to use all the numbers. They're telling only for the employment-based, they're going to use all the numbers. So you need to keep the pressure on it. I mean, it's not that, we want to do injustice to the family-based, but hey, you guys are suffering. You need to have your voice, and please keep writing these letters. Emily, what do you do when, there are some cases where prior to date is current, but they say, well, prior to date is not current, and we're going to hold your case right now? What do you do? Do we contact the Congressman? Do we contact the Ombudsman?
Yeah, I think it depends on the situation. So a lot of people, after they submitted the supplement J to move into EB-2, are seeing that online case status change, saying that your processing has been paused because a visa number is not available. USCIS instructed AILA last week that not to worry, that just means that they haven't actually transferred you into EB-2 yet, even though they've issued that receipt notice. That doesn't mean they've used their discretion to actually put you in EB-2. That's why you're seeing that. But in the situation where, maybe the 485 was filed based on the filing date correctly, and then now we get a denial. That just happened this week. That's a situation where I think the Ombudsman is more likely to help, or a situation where they deny, saying that a visa number wasn't available when you filed, or it's not available now. Those are clear errors, and that's something that the Ombudsman can do, but you have to be careful in a denial situation, because there's also a deadline for filing a motion to reopen or a motion to reconsider, and the Ombudsman can take longer than that deadline, so you really have to do both in that situation. Other areas where the Ombudsman can help is really where there's a major... Can
you explain who the Ombudsman is, how to contact the Ombudsman, Emily?
Yeah. So
let's say they have issues.
The Ombudsman is kind of an oversight control over USCIS. Not really control, but they keep watch of what USCIS is doing. And so they're kind of the party that you can complain to if there's a problem in your case. Right now, they're fielding a lot of complaints. A lot of people are submitting requests for case assistance.
Genuine complaints.
Yes. The problem is they're getting so many that they have to prioritize them. And so they're really only responding quickly to the ones where it's a really big, major no-no by USCIS. And so in that situation, like when they've denied because you filed under the filing dates when you were allowed to file under the filing dates or something like that, you can fill out a DHS 7001 form. It's online, and you fill out the information of your receipt notice, your case number, when it was filed, contacts with USCIS, and then what's going on with the case. They kind of do an initial triage to see if it's something that is severe enough that they need to help with right away. And in that situation, you might hear back from them in about 2 days, letting you know at least they're looking into it or asking for additional information. From that point, it might still take more time, but that's a good sign if you hear back relatively quickly. If you're filling out that form because your case is just taking longer than you want, but it's still within the normal processing time, so you can't do a service request, the Ombudsman is not going to be able to help on your individual case, but it is important to let them know that this is happening across the board so that they can make their recommendations to USCIS and put the pressure on them to improve their normal processing time, which are unreasonable.
Emily, what about the delays in the H4 EADs, green card delays, and emergency advance parole? Whom do we contact?
Yeah, those are likely where your congressman or senator is going to be more helpful. A lot of times when it is delayed, but it's still within the normal processing time, even the congressman or senator's office is not able to help. But if it's an emergency situation, you've tried to do an expedite for an advance parole because you need to travel due to someone's life or death situation outside the U.S., that process is not fast or easy through USCIS. You may be able to get a better response through your congressman's office for something like that.
Emily, can a person study full-time on H4?
Yeah, there's no restriction on that at all. I mean, what would why would someone choose an H4 over an F1 for study?
I don't understand. H4 has all advantages for study. One thing, they will be qualified for in-state tuition, most of the states. That's the reason why people, then they say, I want to study an F1. I don't know what craze they have to go on F1. I personally, myself, studied on H4 visa. I did not had a F1 visa to go to the college. And
you don't need an EAD to study on H4, right?
No, I don't need an EAD. And nowadays, these people have the luxury that the spouse can get the I-140 approved, and they can get EAD approval, and H4 they can study and they can work, they can do internships, whatever they want to do it. The amount of money they spend on F1 visa to get this F1 status and all those things, if they put the same effort on getting their spouse I-140 approval, they'll be much better off. And there are a lot of people who ask the question, if I study on H4 and if I get the master's degree, can I be eligible to file in the master's quota, or will I still be eligible only in the bachelor's quota?
Yeah, absolutely. If you get the US degree, the master's degree, you can file in the master's quota. You don't have to be an F1 to file in the master's quota. That's a common misconception.
That's a common misconception. Obviously, if you are on H4, you will not get a OPT or STEM extension. That's not available for the H4. Obviously, you need to look into H4 EAD options. That's more easier compared to the OPT EAD. Emily, if you given a choice though, if I want to go on H4 EAD and OPT though, I'm going to take H4 EAD because in the OPT, I have to work for a company in a certain position. I need to report it to the DSO, and I cannot have an unemployment period of more than 90 days. In total unemployment period in the F1 OPT and STEM extension is 150 days, and I have to report and I have to only work with the e-verified companies once I go to STEM extension, and I have to complete the 983, the evaluation, submit to the DSO. If there is any faults, which we see sometimes, if there's any faults, they get deported sometimes for the F1 OPT. But in H4 EAD, I mean, you practically can do anything you want to. You can flip a burger in McDonald's, you can be a Microsoft CEO, you can just sit down at home, do nothing. I mean, with the H4 EAD. So definitely a lot of options are there, but I don't know why people prefer F1 over H4. Now, if they don't have a H4 option, then it's definitely F1 is a good option. When I got an I-20 from India, Emily, in a master's degree for LLM to go to Indiana University, Bloomington, I was getting married and she had an option of H1. I came on H4. I mean, I thought that was easier to come, easier to study, easier to become a lawyer, because when I want to take the bar courses, they are not approved for F1. How can I take the bar pre-courses on F1? You can't. I mean, it can only be taken on H4. So definitely, I choose myself to come on H4, stay on H4, and study on H4, become a lawyer on H4. Then at that point of time, I had an EAD. So definitely, I personally myself have chosen to be on H4 rather than F1. I don't know how I can advise when you have to apply for change of status. Every time you go, especially if you come on H4, you want to go out for stamping, then you have to get the stamping for F1 to come back. And sometimes that F1 can be rejected too. And then all the restrictions that you have on F1, I don't understand them at all. And these people sometimes end up paying 3 times the fees on the H4, on the F1 as compared to H4, because most of the states, you are a resident if you're residing for a period of 1 year on H4. So you are exempt, you come under the institution, which I did qualify when I was in Texas. I paid institution stuff out of state. So that's another reason why I choose to be an H4 rather than F1. But it's up to you guys. I mean, that's my option too. And as you said to me, you said to the people very clearly that if they complete the master's degree, even though they are in H4, they can still qualify under master's quota. Are you sure about it, Emily?
Absolutely.
We know that very certainly. We just want to let you know about that too. Emily, what about this? Nowadays, we see H4 EAD getting approval, but H4 is not getting approved. Can they work?
Yeah, that's a really good question, because the the H4 EAD is supposed to be based on your H4 status. If you have an EAD but you don't have your status yet, and a pending H4 extension is technically not status. So I think that's a little risky to work there. I don't know what USCIS is doing, because how can they approve the EAD?
I see that the Attorney General of the United States through USCIS has approved the EAD. I don't see why they cannot work, though. That's my interpretation. And especially for the I-9, though, it definitely qualifies for EAD qualifies. I don't see any reason why they cannot work. I want to give a couple of updates, Emily, especially the PERM labor certification. We're noticing approvals that we filed in November first week to about December first week right now. Is that what you? And also the prevailing wage is taking 6 months. Emily, we have also noticed that the EADs are getting approved, but the advanced paroles are not getting approved when EAD and advanced parole is filed in the adjustment of status. So in that case, can they work?
Yeah, absolutely. The EAD does allow the work. The advanced parole, the purpose of that is just to give you advance permission to travel without the need of getting the visa. So once you get that EAD, you are authorized to work, but you've got to hold off on travel unless you're in H4L status and coming back in H4L status.
What's going on the premium processing of the I-140 assembly? Now, previously, we were having a lot of rejections for the premium processing for the downgrade people, and many people said you can't even file the premium processing. We said we can. I mean, we did, but of course we got some rejections. What's going on that?
Yeah, that's definitely improved to where now if you file an I-140, a downgrade situation or an amendment situation where you don't have the original labor certification, you generally, once you get that receipt notice of the I-140, can turn around and upgrade it to premium processing. And I've generally gotten those accepted and gotten the approvals within the 15 days. So they seem to have figured out whatever the delay was in getting those original labor certifications from one file or to another, or from the DOL to USCIS. They figured out that process and seem to be doing a much better job with that.
Anything more, Emily, before we go to questions and answers?
We can head to questions.
We're going to go to live question and answers. So if you have any questions, please post it on and we'll try to answer as much as possible. If you have written letters to the Congressman, please let us know. We do try to give preference to the people who are contacting the Congressman to improve the situation of the USCIS, because that's what we would like to do. I got a question from Dinesh Lakhani from Facebook, from YouTube, sorry. His petition has moved from Texas to NBC San Antonio. That's a very good news. However, I'm in Boston. Is there an issue? And do they think AO is pending along with the interfiling application? Can they take longer time to approve? Now, here's the thing though. Moving to San Antonio is definitely a good thing. What they're doing, Dinesh, is that if the particular district office have less load though, they're taking up the cases. So even if you are living in Boston, the San Antonio office can take up the case and can adjudicate the case without any interview at all. That can happen. They can even invite you to come for the interview at Boston. They have an authority to actually invite you to come anywhere nearby Boston also. There's nothing required that you have to go to Boston. But we have not seen that occur, even though the USCIS said that they can always call outside the district also. But we haven't seen that though. So we have, especially in the 485 situation right now, in employment based, we have seen the cases getting distributed to different districts. Even if you're not in the district, that district can adjudicate your 485. That is very common nowadays. And it's a very good news for you, Dinesh, that your case is in San Antonio.
Regini says, is it possible to convert from an L1B to an L1A? Yeah, there are certain situations where that's possible, especially in the situation where your U.S. position has been promoted. So you came into the U.S. in a specialized knowledge capacity and you've been promoted to a managerial position or even an executive position. You can convert from the L1B to the L1A to gain the extra 2 years of L time, to have the 7-year limit instead of the 5-year limit. But that conversion application has to be filed 6 months before the end of your 5 years of L1B. So that's one thing to know. And the other thing to know is just because you do qualify for that does not mean you automatically qualify for the EB-1C green card now. So yes, you get the L1A, but you can get an L1A even if your position abroad was specialized knowledge. You cannot get the EB-1C where your position abroad was specialized knowledge. So that's one thing to be aware of with that.
Amit Agarwal is asking this question, that he filed a downgrade application in October 2020, then he upgraded it in May of 2020. With regards to the AC 2180-day rule, is it 2020 or 2022? When it comes to the EB-2 though, the USCIS is telling, for some reason, I don't know where they came up with the rule, that if you want to use the EB-2, that you have to stick with the company for 180 days after you file the upgrade from EB-3 to EB-2. That's what they're telling right now though. Kushi Thakur has a question, do you recommend interfiling? Most probably the other question is, do you recommend interfiling or refiling? It's a very tough question though. We try to publish the stats though. If you go to immigrationgirl.com, now we put a link down in there where we publish the stats with regards to how the approvals are coming from my desk in my office, though. Only my desk in my office. So that's published by Emily, so you can look into those things. Obviously, we have done more interfilings than refilings. That's what. But if you look into the cases that are getting approved, there are a little bit more refiling cases that are getting approved. But I think so the trend looks to be that it may change though, because until the first week of May or second week of May, we didn't have any interfiling approvals, but we started getting the approval from the second week of May. So it's getting more higher for the interfiling. So it's a very hard choice to make whether you should do interfiling or refiling. Can you do both? Yeah, you can definitely do both.
Kimlesh says he heard that USCIS mentioned in an interview that applicants that filed till April 2022 are supposed to get all approved. What's your opinion? Yeah, so that was in the Ombudsman engagement that they did specifically for employment-based immigration. They did an hour-long call where they discussed all of the hurdles and burdens USCIS has had with trying to get these cases adjudicated going all the way back to 2020. And they did a question and answer at the end that said, they answered very clearly, if you filed in April 2022, you should be able to get your approval by September 30th, 2022, assuming the final action date is current based on all of that. I think...
Well, wait a minute. So let me ask you the question. So for the people who filed before April of 2022, are before April of 2022 or in April of 2022? Because when I look into the stats though, here is a stats that from our office is that the cases that were filed in March of 2022 are getting approval. I can see that. Mm-hmm. The one that you published in Immigration Gov. But what about the cases that we filed in October of 2022 that are not getting approval?
Yeah.
So what did they said in there?
They didn't say anything. All they said was if you filed in April 2022, you should get your approval. And then later they said if you file in the first week of June 2022, you should get your approval. My interpretation of that is if you filed a standalone 485 based on an already approved I-140 and your final action date is current and your file went directly to NBC, did not go anywhere else, didn't get transferred to anywhere other than maybe a local office, a field office, those are the cases they are talking about. Standalone, simple process. They don't have to worry about transfer the underlying basis. They don't have to worry about grabbing the file from Texas or Nebraska and transferring it somewhere else.
Interfiling.
Right, yeah. Now, there's a little confusion there because in the AILA update, they interpreted it as interfiles and filings in April 2022 should get it approved. I only heard the filings part. I did not hear the interfilings part, and that webinar is not publicly available, so we can't go back and listen. But then they later came back and said, no, even if you file the first week of June, filing the 485, you should get the approval. I think they're fast tracking the things that were filed later that are easier to process, went straight to the NBC.
Then the cases that we filed in October or November of 2020. Mm-hmm.
Yeah, that's what we're seeing from our statistics, and I think that's, unfortunately, they're trying to do the low-hanging fruit where it's the easier application because everything's in one place. They don't have to worry about this.
What do you think so is a problem of the USCIS, Emily, that it's becoming easy for them to adjudicate the cases that are filed from January of 2022 to right now as compared to October of 2022 to January of 2021?
Well, number one, those in October 2020 generally went to Texas and Nebraska where they got stuck with the I-140s. They did not have the capability to handle the I-140s that were filed as downgrades, let alone the 485s on top of it. So those cases just sat there. Remember the form in October 2020. It was a confusing form. They changed and they had these different questions on there, how you qualified. They had the questions about your, public benefits were on there, and you had to select just the right boxes. And if you select the wrong boxes, it was very confusing.
Whole application
had to submit the 944. So there were all these additional things that had to be done in October 2020. Just to scan those
pages, it took a long time for
them. Some of those files were that thick because of just the credit report and the financial documents, which are useless now. So I think that is one of the big problems. And then, of course, they're all in EB-3, and USCIS historically has not had a great process for this whole interfile request transferring the basis from one to another. Now we have a process, but they still had a front log in getting those receipted and uploaded and scanned and all of that, which again caused delays. Now they're finally getting caught up on that. It remains to be seen how quickly they can get that information to the officers. Are they still transferring cases from Texas and Nebraska to NBC? They said they're not done transferring cases. But can you get them to transfer your case? No, there's no mechanism to force them to do that. So if you're in Texas or Nebraska, you're kind of stuck until they figure it out.
One thing I feel a good news is that at least the premium processing I-140s are getting adjudicated very fast. So there is a good indication that the October cases may move to. That's the indication, but we strongly believe if the case has been filed from October of 2021 to June, though, there is a good possibility they will be adjudicated by September 30th of 2022. But the ones that got stuck before, definitely we'll have to see how the things will move, because it's not easy for them to move from one place to another place and adjudicate it, move from EB-2, EB-3 to EB-2, EB-2 to EB-3, and then vice versa. They don't have the mechanism previously, and they're trying to make the mechanism. I don't know how long it's going to take. So I hope, please keep writing the letters to the Congressman, guys.
Ram says his PERM application was filed without the A number and class of admission. Are these mandatory fields? Will this cause an issue? No issue at all. I think our office leaves them blank in pretty much every case. It's not relevant at all to the PERM. I don't know why they ask for it. So no issues at all.
One Rahul Shah, who wrote letters to the Congressman, thank you very much. When we get a medical RFE, does it go to the attorney, or should the attorney respond to the RFE, or can it be responded by the applicant though? Especially RFEs normally will come to both Rahul Shah. It will come to the lawyer, and it also comes to the applicant though. In our office, the habit in our office is that if it's just only medical and we read it, make sure that it's only medical, we tell the applicant to respond though. If it's anything else other than medical though, then we tell that we will respond. We don't want the applicant to respond if anything else. That's our office practice. But there may be other law firms that may say, hey, we are going to respond to the medicals. That's up to them. There's nothing wrong with it. But if it's only medical though, I mean, there is nothing. We can't even open the medical package. You give us a medical package, we get the FedEx, we FedEx it to the USCIS. I mean, why waste one FedEx and some extra 2-3 days? We tell the applicant to do it. Just submit it to them. That's what we tell them.
Vinod says he applied for the 485 using the filing date chart for EB-3, and if he's interfiling to EB-2 using the final action date, since the derivatives don't get a receipt notice for that, which date will be used to calculate the CESPA age, the 485J or the kid's 485? So in order to lock in the age in EB-2, they look at the date that your 485J was received, even though the kids don't receive their own receipt for that. So it's based on the, is the final action date current on the date your 485J was approved? If your child's age is under 21 at that point and that EB-2 I-140 is already approved, their age is locked. If the child is over 21 at that point, then they look at how many days was the EB-2 I-140 pending, subtract that from their age, and see if that gets them under 21 on the date the 485J was received.
Sojan is asking the question, is the H4 is only for spouse of H1B holders, right? Or can the kids above 21 must go on F1 or H1? Sojan, a H4 is only for spouse, not spouses, only spouse, and kids under 21 unmarried, both. If the kid is under 21 and married, then they get kicked out of the H4. And if the kid becomes 21, they get kicked out of the H4. They have to go on F1, H1, or any other visa that they may be eligible for. But once they become 21, they cannot be an H4. They get kicked out. They are independent though. Now, if there is an adjustment of status pending and they are covered under CSPA Act, I don't know if you don't know that, then you definitely need to refer that. If you file the 485 and the kid is aging out though, if the kid is already protected in the CSPA though, then the kid can use the EAD of the adjustment of status, even though he becomes 21. He gets kicked out of the H4, but he doesn't get kicked out of the adjustment of status though. If the final action date is current, he's protected under the CSPA. Then he is definitely good to use the EAD. But there is no H4 EAD for children under 21. It's not available. It's only for the spouse, not for the children. And for L2 EAD also, a lot of people ask this question, is it available for the children who are under 21? No, the L2 EAD is only for spouse, not for the children.
Sukanya says her husband downgraded from EB-2 to EB-3 in November 2020, got the I-140 approved and the EAD card. He is still with the same company, but he switched his job from a quality engineer to a product manager and wants to know what they can do now. Well, I think a lot of it is going to depend on what the company is willing to do in terms of that EB-2 approval to see if you can interfile and take advantage of EB-2 in that situation. And that's likely going to be determined by what their attorney guides them on. There are some attorneys that say, nope, the job changed. You can use AC-21 to change jobs, but you're stuck in EB-3. And you can only interfile the EB-2 if the job is exactly the same. There are other attorneys that say, well, let's look at this changed job. Is it really that big of a change? Is it a material change? Or is it just part of the normal career progression of this person to see if they can somehow still keep that EB-2 and be able to interfile? And that really depends a lot on how the attorney is guiding the company on that. And so definitely talk to your company to see what the options are if they'd be willing to let you interfile to EB-2.
Malik Chilka has this question, can I submit medicals along with the interfile petition? Our advice is not. We have advised so many people to do interfiling without the interfiling of the ACE. When you say interfiling, you mean to say when you do interfile from EB-3 to EB-2, we do not want you to include the medical. We want a stand-alone interfiling of the medicals. We have recommended this to so many people. I get emails, calls, messages that they got the green card when they did interfiling, stand-alone interfiling of the medicals. So we are still stand the same thing. There are some people who have done the medical interfiling along with the EB-3 to EB-2 conversion. We recommended against, but maybe if once they start getting the green cards, they can report it back to us and we can support the decision. But for now, we're standing that with interfiling of EB-3 to EB-2, do not file medicals, file interfiling of medicals standalone.
Nahid wants to know if the Nebraska Service Center is still adjudicating 485s. He applied for the 485 in January 2022. No updates other than fingerprinting. When can I expect any action on the case? So technically, yes, they can still adjudicate the 485, but they're really only working on the cases where they've gotten so far along into the process that it doesn't make sense for them to transfer the file to the National Benefits Center for conclusion, such as the situation where they've issued an RFE for something that was missing and now the RFE has responded. They're not going to now send that case to the National Benefits Center. It's going to be stuck in Nebraska and they'll eventually get to it. But for other cases, in most cases, if the Nebraska Service Center hasn't really done anything on the file yet, then they are still transferring those. But there's nothing you can do to kind of force that transfer process to happen. And most likely it'll be transferred and then adjudicated by NBC or a field office.
Dinesh Patel has this question. I received my green card on May 12th, 2022, I'm assuming. My employer has a position open closer than my home. Can I transfer my location? Absolutely you can. As soon as you get the green card though, you can stop working. You can flip a burger in a McDonald's. You can be a Microsoft CEO, whatever you want to do it. And you can change your location. Absolutely not a problem. You don't have to wait for anything.
Raghu says, is there any requirement that the 485 needs to be filed within 1 year of the priority date being current? Will I be eligible for H1 extensions? My new employer has not started the PERM. So there's no requirement that the 485 has to be filed within 1 year of the date being current, especially when you don't have a new I-140 from your new employer to support it. The issue though is, how do you stay in the US if you can't keep getting H1 extension? So the rule with that is, once you your final action date has become current, you can only get 1 year extensions, assuming that your PERM was filed at least 1 year before you hit your 6-year limit. And you can keep getting those 1 year extensions as long as you filed the 485. If you have not filed the 485 within 1 year of the priority date, the final action date being current, you can still request a 1 year extension of your H-1B status, but it's up to the discretion of USCIS whether they will grant it or not. We've not had people not get the extension, especially where the PERM is in process. But are they going to let you keep getting the extension for the next 5 years when you've not made any progress on the, with your new company? No.
Emily, have we seen any denials on that though?
No, but at the same time, the final action date hasn't been current for an entire year for most people, especially the ones that did the downgrades. But generally, we are seeing people getting that first extension, and by the time their first extension is done, hopefully they have the new PERM in place and I-140 filed. Now they filed the 485. Getting that next extension, if they've not made any effort to start the process with a new employer, that's where you might be in trouble.
Srinivas is asking a question, can a refiled case will be considered as a standalone application? What Emily's meant by standalone application is that if you are not attaching with the I-140 application though, that means that you're not filing downgrading application of I-140, or you're just filing I-140 and 485. That means that it's not a standalone. If you file only 485, along with that, you file 485J supplement I-131, which is called Advanced Parole 765, that is considered as a standalone application. When you add I-140, it's not a standalone application. Why did she said, why is there so much difference? Emily, why is there so much difference between standalone and I-140? Why?
Yeah, that's a really good question. I think that
the service centers, if you file an I-140 and 485, the I-140 normally cannot be adjudicated by the National Benefit Center though. It has to go to Texas Service Center or Nebraska Service Center. Those are the only two places. Now, once it goes there, there's a big black hole there that they're not working and they don't know what to do with it. It's like a monkey getting a book. They don't know what to do with the book because the monkey doesn't know how to read it. And that's how the Texas Service Center and Nebraska Service Center has been behaving with the I-140 and 485 applications. Now, they were not used to these many I-140 and 485 filed together. There are not many officers who are trained to adjudicate I-140s and 485 though. So it goes to Texas Service Center, they open the whole thing out. Now there are two things. One is I-140 and 485. One officer can only adjudicate I-140, one officer can only adjudicate the 485 application. So first the I-140 has to be adjudicated. Then once the I-140 is to be adjudicated, it has to be transferred to a different person. There is an entire bureaucratic process. It's not like you take this file and give it to Emily. That's not how it works out with the USCIS. There is a completely different process there. And the process involves a lot of paperwork, a lot of these things, and that is the whole confusion that they have when we file these I-140s and 485s. That's where the problem arises though. Now, did they used to adjudicate these things before? Yes, they used to adjudicate this before with the I-140 and 485 filed together. They used to, but not the number of cases that we have seen, especially filed in September, October of 2020. And not only that though, they may be the rest of the world countries, and we normally can file I-140 and 485 together. That's also acceptable, especially when the I-140 has been filed as a downgrade application, where the labor certification, original labor certification has already expired. They are definitely not used to that. And that's the reason why we feel that standalone applications are getting approved much faster, because it goes to the officer, I-140 is already adjudicated. All I need to do is look into the 485 and approve it. And that's why there's a lot of discrepancy between standalone application and I-140 and 485 application.
Suman says, for the H4 EAD, my spouse changed his employer. My H4 is stamped with the previous employer. Do I need to apply with the old employer's 797 details or the recent one? So I'm assuming you're filing the I-765 application to get your EAD, and for that, the visa stamp is irrelevant. You need the most recent I-797 approval notice, which shows that your spouse has been granted the H-1B status beyond your current status, so that you can get the EAD based on that longer period of time. If you just submit the old I-797, you're only going to get an EAD that expires whenever the old one expires. But the fact that the old employer's name is on the visa stamp, not relevant at all to the H4 EAD application.
Ibrahim's priority date from Facebook, Ibrahim's priority date is November 2014 EB-3. Just wondering how much time it's going to take to adjudicate my case. First of all, to adjudicate your case though, your final action date has to be current. It is not current though. I don't know how long it's going to be current. But Ibrahim, I would recommend that you should have an option of EB-2 though. So if you don't have an underlying EB-2, I will seriously considering filing a labor and I-140 for you to have both options. If your labor certification is, if your I-140 already is approved in EB-2, definitely you can wait for the final action date to become current and try to do the interfiling. Until the final action date is current, they cannot adjudicate your application. And I cannot project when the EB-3 November 2014 is going to be current. It's very hard. I want you to be prepared to have options for both.
Shilpo says, I've downgraded to EB-3 in October 2020, applied for the EB-3 in premium back on May 25th for that I-140, and it's still pending. Should I wait for the I-140 approval before doing the interfile back to EB-2, or should I proceed with the interfile anyways? So I'm assuming you have your EB-2 I-140 approved, your EB-3 I-140 is pending, you've upgraded that to premium, but still no approval notice. So technically, you're eligible to interfile based on the pending I-140 and the approved EB-2 I-140. You don't have to wait for the EB-3 I-140 to be approved in order to interfile. Now, where does that EB-3 I-140 approval become important? From what we're seeing, even though you interfile, they may not transfer your case to the National Benefits Center until the EB-3 I-140 gets approved. So you can still interfile, but you're still going to experience some delay based on what we're seeing of actually getting the 485 adjudicated, because that EB-3 I-140 is still hanging out there. They won't move the 485 away from it until it gets approved.
Harsh has this question. He wrote a letter to the senators. Thank you very much. Can a U.S. citizen apply for a fiancé visa if the person is already married? Well, the fiancé definition, if you look into the Webster's dictionary or whatever dictionary, means you're not married. But that's not true when it comes to the immigration. Yes, you can still call, they still call it as a fiancé visa. You can still file a fiancé visa. It's called a K3. That's the one that you can file. And that is I-129F you can file. But before filing a fiancé visa, if you're already married, you must have an I-130 receipt notice. You file an I-130 receipt notice, you include it, you tell the immigration, look, I filed an I-130, now give my wife a fiancé visa. It's perfectly legal. There's a particular visa called K3, you can do so.
Dennis says, how soon can a person change the work site for the same employer after receiving the green card? I received my green card last month. You can change the work location the next day. There's no requirement that you have to stay at that certain job location for any period of time after receiving the green card. Because remember, the whole 485 process is based on an offer of employment, not actual employment. It's just saying that you intend to take that job when you get your green card. Now that you have your green card, there's no restrictions on you at all, and you can change work locations without any issues.
Mahanti has this question. Can I refile the application after interfiling? Yes, you can. Yes, you can. There's nothing illegal about it. Absolutely, you can. What's going to happen with all these cases where people are refiling the cases, though? Emily, we used to get a lot of administratively closed cases, though. But today, I'm so happy that I got about 7 cases that I've seen. No, 3 cases, green cards, I got denied. I'm so happy. And when I look into it, they said your 485 has been denied because your other 485 has been approved. I don't care. That's the happiest denial of the green card I would ever take it. They said you can't appeal. We don't want to appeal it.
Srinivas said, I refiled and my final action date is current, and both the EB-2 and EB-3 are at the National Benefit Center. Can I expect my case to be adjudicated by this September?
That's a target.
Yeah, so assuming that your EB-2 I-140 was approved when you refiled, and the refile went straight to the NBC and it stayed there, and your final action date is current and you filed before June 2022, USCIS says they're going to approve those by the end of September.
Here is what Rao from YouTube has. USCIS has heard your voice. It's not my voice, it's your voice, guys. I'm a US citizen, believe me. I'm a US citizen. It's your voice. It's you guys, you writing the letters, you voicing it. That's the reason why the USCIS heard it. You were writing those consistent letters. I mean, I've never seen so much action. At least they're positively saying that every time in their tweets, in their messages. Thank you for all of you guys for writing the letters. They heard your voice. That's for sure, we can tell that.
Chetu says, I wrote letters to the senator. Can I change employers after 180 days of the I-140 approval? And the 180 days are calendar days, not working days, right? So the 180 days is relevant in 2 different scenarios. So I'll talk about them separately. So let's assume that you have not filed the 485 because your priority date is not current and you got your I-140 approved more than 180 days ago. Can you change employers? So assuming that you can file an H-1B transfer, for example, and you're moving to the new employer, yes, you can. And what waiting that 180 days does is, number 1, it makes sure you can retain your priority date. Number 2, it makes sure that even if your old company goes back and withdraws your approved I-140, USCIS will not revoke it. That means that you can still use that old company's I-140 approval to keep getting H-1B extensions beyond the 6-year limit, and your spouse can keep using the old company's I-140 approval to get H4 EAD extensions. So those are the benefits you get by waiting 180 days after the I-140 is approved before you leave that company, assuming your 485 has not been filed. Now, if your 485 has been filed, yes, there's a 180-day rule, but the 180 days is how long has the 485 been pending. It's not relevant how long the I-140 has been approved in that situation. If your I-140 is approved and you filed your 485 and you've waited 180 days after filing your 485, you're eligible to move the whole process with you to the new employer under AC 21, as long as the new job is in a similar occupation, and as long as you either have your EAD to be able to start work for the new employer, or the new employer is willing to file an H-1B transfer for you.
Pradeep Koirala has this question. Can the US citizen sponsor for siblings who are on H4 status or Indian citizen, how long it will take for them to get the green card? Yes, they can file a family-based fourth preference petition. Right now, the final action date is in 2005, so approximately around 17 years is the waiting period. Now, the time period can fluctuate, Pradeep. I mean, it cannot be, when I say 17, it doesn't have to be 17. Sometimes it can be 15, sometimes it can be 20. So that's a period you can expect. Now, they cannot stay in United States just because the I-130 has been filed. They have to still maintain the non-immigrant status, or they can go to India and then come back in a green card. They can do that, or they can maintain the H-1B and H4 here until their priority date is correct.
Ryan has written a letter to a congressman and says, can I go for stamping in Canada or Mexico? And if the visa is rejected, can I come back to the US on the approved H-1B copy? So prior to COVID, yes, you could go for stamping in Canada or Mexico. Even during COVID, technically, yes, the problem is you can't get an appointment because they're so backlogged they're pretty much only allowing appointments for Canadian or Mexican citizens or legal residents there. So you'd very unlikely be able to get an appointment. Assuming you could get an appointment, yes, you can go for stamping there in most situations, unless you entered on a B visa first. But if the visa is rejected in Canada or Mexico, you cannot come back on the approved H-1B because you don't have a valid visa. There is visa automatic revalidation, but that only works if you did not go for stamping. So if you went for stamping and got rejected, your only option is to go to your home country and apply again.
My spouse has unexpired H4 EAD but changed to H1B within USA. If she goes to India and comes back on H4, can she use the unexpired EAD? She can. I don't see any reason why she cannot. It's been approved, it's been never been revoked. She came back on H4, so she can definitely work on H4 EAD. Prashant has this question. His priority date, his final action date is current right now, and he recently filed interfile request from EB-3 to EB-2 when he's going to get the green card. Oh, well, it could be anywhere between 4 months, and we don't know how long it's going to take. I want you to watch the Immigration Girl link that we have provided there, so we keep updating there on the cases that are getting adjudicated.
Dinesh says he's got the employment-based 485, 765, and 131 all pending since July 2021. He needs to travel out of the country for work. What are my options? So part of it does depend on what your status is right now. If you have H or L status and you can go and come back in H and L status, you can do that without the need of the advanced parole and without abandoning your 485. Now, of course, if you need a visa stamp, an H or an L stamp to be able to come back, you may have to delay your trip until you can get that appointment scheduled to be able to get the stamp and then come back. If you're not in H or L status, your only option is to wait for the advanced parole or wait for the green card to be approved. You may want to consider litigation that is working for these delayed interim, what we call interim benefits, the EAD or the AP. If those have been delayed more than 6 months, that is an option as well if you do truly need to travel, especially for work situations. You can reach out to Stephen Brown in our office on the litigation side.
Emily, I need your attention a little bit for the question that is coming from Satish Gangisetti from YouTube. His green card is approved, but his category is E37, which is EB-3, but he's not current in EB-3, but current in EB-2. What do you do in this situation?
So yeah, I've had that happen recently.
Very
recently. And
very many times.
Yeah. And in my case, it wasn't even current in EB-2, and I still got an approval that said EB-3. So what we learned after contacting the Ombudsman office was that the approval was correct. At one point, the EB-3 date was current, final action date, and the I-140 was approved. They assigned that person a visa number, and then the dates retrogressed before they got around to actually approving the 485. And then months later, they finally got around to approving the 485 and approved it when neither of the dates were current.
I'm wondering where they got all this justification. If that's the case, they could have used all 290,000 green cards.
Exactly.
Though. But anyway, in Satish Gangisetti case, his EB-2 is current though. I would not even contact the Ombudsman. I will not do anything because his dates are current anyway. So that's a choice. But yeah, when I contacted, in my case, Emily, we filed the EB-3 485 application with company A, and he had a company B, which was the old company EB-2. They used that, and they justified that saying that we use the old company's EB-2 approval. Well, I said, okay, I'm not going to do anything. We made whatever we want to. But in Satish Gangisetti case, though, if both are current, they have given you EB-3 category, I'm not going to do anything. Don't do anything. And the ones that we have done the things, though, we took the money, and then still the USCIS said it's fine. In that case, why waste the money on the lawyers? I would keep quiet if I were you.
Srivastava says, if I move to a new employer, does the I-140 need to be filed again? It depends on the situation. Have you filed your 485 already? And if yes, has it been pending for 180 days? If that is also yes, then you can take your whole green card process with you to the new employer, and they don't have to file a new PERM or new I-140. All they have to do is submit a supplement J form to confirm that they're offering you a similar job. So that's assuming you filed the 485 and it's pending for 180 days. If you have not filed the 485 and you change employers, you will eventually need your new employer to file a new labor certification and new I-140, because you cannot use your old company's I-140 to support a 485 if they're no longer offering that job to you.
Chandra has a good question though, that 485 has been filed with just the receipt notice. Does it straight go land in the NBC? It still should be considered as a standalone application. We strongly recommend to wait until approval comes in though. I don't know why you did not wait it though, unless the prior dates are backtracking. I would normally have waited for your approval though. That's what we normally, when people come and say, hey, let's file I-140 and 485. So no, let's wait one thing. Let's file I-140, get it approved, and then. But if the prior date is backtracking, then at that point of time, we normally will file with the receipt notice, or sometimes directly also.
Gotham says the H4 EAD got expired on February 8th, 2022. Did not apply for the extension yet, but I have a valid I-94. If I submit the extension today, can I start working from tomorrow, or should I wait for the approval? Unfortunately, you have to wait for the approval, because there's no auto extension of your EAD when your renewal is filed late. That only works if you had filed your EAD before February 8th, 2022. So in this situation, unfortunately, you'll have to wait until the EAD is approved to start working again.
Emily, I want to discuss with you, I need your attention on this thing, is when a person doesn't have a standalone EAD, just for example, H4 EAD or adjustment of status EAD, I mean, they can do anything they want to. I mean, they can sell they can flip a burger in McDonald's, they can be a Microsoft CEO, they can sit at home. Those are especially adjustment of status dependent EAD. But when people don't have a work authorization though, can they get income from Instagram, YouTube videos?
I don't think so. I don't think that's passive income.
That's bad.
You definitely are doing something.
What about if I go to stock market, I buy Microsoft and I make $100,000? Can I get that income?
Yes, that's fine. What you can do is passive income, not employment. So even though you feel like, oh, I'm doing YouTube videos, I'm not working, it's just for fun, I'm volunteering, and I'm just getting money from it just because of the ads or whatever, you're actively doing something to get that money. You're not buying a stock and just receiving the dividends from it. Dividends is not the same as getting payment from some work that you've actually done.
Now, if you're doing something voluntarily, for example, I mean, you get a little bit payment though. There are ways to say, divert that payments to a charity, saying that you're doing for charity. That probably you need to discuss with an immigration lawyer to make sure that you're not doing it for the income's sake though. If I run for a charity and then I get $100 prize if I run though, then you can give that $100 to as a charity, then probably it may qualify. But you have to check with each individual situation if it qualifies though. Is it a token money or what kind of money it is? Especially when it comes to the Instagram or YouTube, we think so it is very actively working because you're actively doing some activity. Based on that, you're getting income. It's not for a passion where you're not expecting anything back. Did I interpret rightly?
Yeah, I agree with that.
Yeah, because if I go run a marathon, I get a medal. Is it a monetary reward? It's not.
Right.
Yeah.
Yeah. Praveen says, wants to know if a spouse has an unexpired H4 EAD, but changed to H1B within the U.S. and then travels and comes back on H4 from India, can she use the unexpired EAD? There's no guidance from USCIS on this, but I think the answer is yes, given that the USCIS guidance is that an EAD remains valid until it either is expired or revoked. And since they did not revoke her EAD when she got the H-1B status, it's still valid as long as she is back in H-4 status.
Rakesh has an interesting question. That if I travel to US on advance parole, will it disqualify my H1B, which is expiring in 2024? Fortunately, no. You can still extend the H1B. You can still transfer the H1B. We have done it, and USC has clearly said that they will honor the H1B until 2024. Nothing wrong with it, and they're extending the H1B. We have also extended the H4s. We did not had any problem with that too.
All right, well, I think we're out of time for today. Thanks so much for joining us. Remember, you can sign up for our newsletter at rnlawgroup.com. It got a new look last week, so we'd love for you to take a look at that. We'll be sending it out tomorrow.
Thank you very much.